number limitation. So they were saying something on that. So let them say that they have to.
Yes, I have gone through the records. In this particular case, this issue was specifically framed by the trial court. Trial court answered that this deed is ab initio void.
Why is it void ab initio?
I may be permitted to read out.
Let us see the reason.
Yes.
And the question of law with regard to
Please, madam. Please hold on. Have a second. Where is the finding?
Yes. My lord, may kindly see issue number 9.
Page number?
Page, internal page 11, my lord, of the trial court judgment. क्या वादी और उनके बहनों द्वारा प्रतिवादी 104 के पक्ष में निष्पादित अंगीकृत नदावेनामा
See, there was the relinquishment deed as well as the gift deeds were specifically challenged in the suit by filing an amendment petition.
Yes.
Right? We are concerned with the limitation to challenging
Yes.
these deeds. Correct?
Release deeds, yes.
Release deed,
Yes.
and maybe even the gift deed for that
Yes.
purpose, because the gift deed has also been declared to be null and void,
Yes.
right? So I just want to know what is the reason for
Yes,
declaring it
that's
as
why I
null?
am showing the issue. My lord, let us see the findings.
So you want to place issue number, you place
Nine.
issue number 9,
One,
then issue number 8, and issue number 4.
Who is relevant?
4?
मर्यादा के
नहीं मर्यादा नहीं, वो कौन सा
मर्यादा
लिमिटेशन कौन सा
विधि में
हुआ?
लिमिटेशन
यही हुआ ना?
लिमिटेशन
हाँ, लिमिटेशन। लिमिटेशन को हिंदी में मर्यादा विधि बोलते हैं क्या? Every day we are learning something or the other. बताइए, पहले ये
नवादे चूंकि इन पर इसी पर वो कन्फाइंड है, सो हम उसी पर रहते हैं।
नहीं कन्फाइंड से उस पर नहीं
नहीं,
रहेंगे,
वो
इसीलिए आपसे बोल रहे हैं आप तीनों को, ये तीनों को आप प्लेस करें।
तो अब तीनों पढ़ देते हैं।
तीनों का क्या फाइंडिंग है?
जी।
पहले
8 कुछ चलते हैं।
8 9
वादीगण का अभिवचन
पेज
संक्षेप
नंबर
में
किसमें 11
जी
पेज नंबर 11
12 फाइंडिंग पर वादीगण का अभिवचन संक्षेप में यह है कि प्रतिवादी संख्या 1 से 4 ने अपने पिता से कपटपूर्ण तरीके से वाद का संपत्ति का पंजीकृत दान पत्र निष्पादित कराकर दाखिल करा दिया, जो कभी भी वादी के समय सामने प्रस्तुत नहीं किया गया और न ही कभी प्रभावी हुए, इसलिए प्रतिवादी 1 से 4 के पक्ष में इनके द्वारा निष्पादित पंजीकृत संख्या सचन सच अवैध एवं वादी पर बंधकारी नहीं। मतलब वन थिंग आई वुड लाइक टू पॉइंट आउट, the prayer is followed that it may be declared as void, not binding, not cancellation. There is a difference. प्रतिवादी गण का अभिवचन संक्षेप में यह है कि वादी एवं प्रतिवादी गण के पिता ने प्लॉट संख्या सचन सच प्रतिवादी संख्या 1 2 3 4 के पक्ष में पंजीकृत दान पत्र संख्या सचन सच द्वारा अंतरित कर दिया और उक्त प्रतिवादी संख्या 1 से 4 ने दान पत्र स्वीकार कर दान पत्र में वर्णित भूमि पर कब्जा प्राप्त कर लिया है और सूर्यनारायण घोष ने अपने पुत्र विजय यादव को पंजीकृत दान पत्र प्लॉट संख्या सचन सच की भूमि दान कर दिया है और उक्त पंजीकृत दान पत्र विलेख संख्या बहुत पहले से ही निष्पादित किया जा चुका है। इसलिए हिंदू अधिकार अधिनियम के 2005 के चैप्टर 2 और 6 के अनुसार संपत्ति का क्रय किए जाने का अंतरण पर इस अधिनियम को कोई प्रभाव नहीं पड़ेगा। इसलिए वादी एवं प्रतिवादीगण के पिता 1 से 4 के पक्ष में निष्पादित पंजीकृत दान अभिलेख वैध एवं प्रभावी उनका कंटेंशन। वादी संख्या साक्षी संख्या 1 ने अपने साक्ष्य में कहा है कि प्रतिवादी 1 से 4 इस बात में अपना बयान तहरीर दाखिल करने के बाद मेरे आवेदन
Let us see what is their contention. आप इसको इंग्लिश में ट्रांसलेट। What is their contention? That these
deeds are valid.
Just a moment.
English
This is
वाला
the
भी
contention of the plaintiff. Contention of the plaintiff.
कंटेंशन ऑफ द प्लेंटिफ ये है कि दिस डीड्स वेयर
Gift deeds.
गिफ्ट डीड्स ये फ्रॉडेंटली इन्होंने करा लिया है अपने फादर से कपटपूर्ण करा लिया है और
fraudulently executed.
करा लिया। कपटपूर्ण लिख रहे हैं, कपटपूर्ण तरीका का मतलब
Okay,
है
fraudulently
करा लिया।
executed
जो
and
कभी भी वादी के सामने प्रस्तुत नहीं किए और न ही कभी प्रभावी हुए, ये कभी भी एक्ट अपॉन नहीं हुआ।
not acted upon.
हाँ।
And what is the reference to this Hindu Succession Act?
ये प्रॉपर्टी जो है, ये इनका भी यही कहना है कि ये पारिवारिक।
उनका क्या कहना है, आप वो छोड़ दीजिए, आप अपना कहना बोलिए।
हमारा तो है ही कहना।
क्या?
हमारा ये कहना है कि ये दादा की प्रॉपर्टी है और पिता माता इत्यादि डेथ के बाद सब में मेरा हिस्सा है। हम जब उनके अपने सगे बहन भाई हैं।
The plaintiffs are the co-sharer of the property.
Yes. Property belongs to grandfather और फादर मदर के डेथ के बाद से सब भाई लोग का अकेला नहीं होगा, बहन का भी।
The property was self-acquired property of grandfather.
No, grandfather का प्रॉपर्टी।
Self-acquired property. After his death, he had a son.
Sons are there. Daughters are also there.
Only one son, the father
Only
of the...
one son.
Just one month.
Only one son.
Yes.
And he had children.
He had a wife,
Uh,
Ahilya Devi, and daughters and sons also.
Daughters and sons.
Sons also.
Who are the plaintiffs in this case?
Daughters.
Daughters
One of the daughter is the plaintiff.
Granddaughter of the
No, daughter. Granddaughter of
the
Granddaughter.
original recorded deed.
When the grandfather died,
मैडम प्लीज होल्ड ऑन, आपसे नहीं पूछा, आपसे पूछेंगे तब आप बताइए। Daughters, okay, are the plaintiffs.
only one granddaughter was the plaintiff.
Under
Other
the
than
Hindu Succession Act,
one.
when a father dies
One.
with his self-acquired property, to whom does it dissolve? To whom does it devolve? The Hindu Succession Act.
As per the
Class 1 कौन है?
son होंगे
और
अगर उनकी वाइफ है,
किनकी वाइफ? उनकी वाइफ होगी ना?
उनकी wife होगी।
उसके अलावा कौन होगा?
उनके अलावा सन होंगे और उनके अगर कोई वाइफ है उनकी वाइफ को भी होगा।
वाइफ होंगी।
ग्रैंड मदर।
ग्रैंड डॉटर्स होंगे क्या? ग्रैंड चिल्ड्रन होंगे क्या?
नहीं ग्रैंड चिल्ड्रन का जहाँ तक बात है वो डॉटर्स में आएंगे, डॉटर्स एंड सन्स का ही होगा क्लास 1।
नहीं देखिए ना, देखो दीजिए जरा हिंदू सक्सेशन एक्ट।
सन होंगे, डॉटर होंगे, विडो होंगे, मदर होगी, है ना, ये सब होंगे।
ग्रैंड डॉटर होंगे क्या?
ग्रैंड डॉटर का तो उस समय बर्थ था कि नहीं बर्थ था, ये चीज़ तो देखना होगा।
हम आपसे ये पूछ रहे हैं
जी।
सिंपल सा बात कि अगर किसी का डेथ होता है,
Right.
he dies with something self-acquired property.
हाँ,
Upon his death,
right.
will it devolve upon his grandchildren as a co-partners, or it will only devolve upon his children if they are able?
That will depend upon the facts of the case.
What?
If suppose if there is a family, if there are sons and there are grandsons and the grandfather also, then the occasion may arise like that.
नहीं ऐसा इस तरह से मत बताइए। There is one grandfather who dies, leaving behind one son,
Living behind one son.
right? Then the property will devolve upon his son, or it will devolve upon his son jointly with his grandchildren.
It will depend. That's what I am saying. That
इसी
if-
केस में बताइए ना।
इसी केस में बता रहे हैं कि ये अगर ग्रैंडफादर का प्रॉपर्टी है तो ग्रैंडफादर का प्रॉपर्टी अगर मान लीजिए उसका अगर हिंदू सक्सेशन एक्ट के हिसाब से अगर चले तो उनके सन को जाएगा। अब लेकिन सवाल है कि अगर कोई कंपाशनरी थी तब वो
किसकी को पास नहीं?
अगर ये अगर कोई ऐसा
इसमें तो कोई ऐसा स्टोरी नहीं है।
देख, हमारा तो इसमें प्लीडिंग वो नहीं है, हमारा प्लीडिंग ये है इसमें कि
There was also a prayer seeking a declaration that it is not ancestral property.
No, it is ancestral property. That what is the declaration? It's secret
Okay,
declaration.
right. They also wanted a declaration that it is an ancestral.
And my lord, they have accepted it. That is an admitted position. उस पर जाने की जरूरत इसमें मेरे समझ से नहीं है, इसलिए कि जब इनका खुद का यही कहना है कि नहीं ये पैतृक संपत्ति है और जो नबादी नामा में ये कह के लिखवाए भी हैं, तो भी इसमें ये और आज तक कभी ये रेज भी नहीं किए। अपना रिटर्न स्टेटमेंट में भी लिखे हैं कि हाँ पैतृक संपत्ति का बंटवारा हो। हम इनका रिटर्न स्टेटमेंट दिखा देते हैं। ट्रायल कोर्ट ने इसे कोर्ट भी किया है, इसको देखा जाए। इनका जरा सा हम इनका पढ़ देते हैं, उस पर तो ये डिस्प्यूट है ही नहीं। देखा जाए हुजूर, पारा 3 एक बार खाली सब देखा जाएगा, पारा 3 देखा जाएगा ट्रायल कोर्ट का। पारा 3
They
देखिए।
sought a declaration that it is an ancestral.
Yes, ये पारा 3 एक बार देखा जाएगी। प्रतिवादी
This
संख्या
declaration has been
1
given. This declaration has been given.
ये एडमिट है हुजूर, इसमें ये खुद ही कह रहे हैं, देखा जाए।
अच्छा, this is not in dispute.
This
that
is
this
not
is
in
an
dispute.
ancestral property.
That is not in dispute. इसमें पारा 3 में हम पढ़ देते हैं। वादी का वाद आवश्यक पक्षकारों के आशोजन के बाधित है। इनका रिटर्न स्टेटमेंट हम पढ़ते हैं। क्योंकि इस वाद में पैतृक संपत्ति के बंटवारा की मांग किया गया, खुद ही कह रहे हैं। और इनका नबादी वाना नामा
पूरा आधा मत पढ़िए, पूरा पढ़िए, आगे
पूरा पढ़। क्योंकि इस वाद में पैतृक संपत्ति के बंटवारा का मांग किया गया है और प्रतिवादी संख्या 1, 2, 3 के पुत्र एवं पुत्रियों को इस बात में पक्षकार नहीं बनाया गया है। वादी का वाद मर्यादा विधि के प्रावधान से बाधित है। वादी के 5 पंजीकृत विलेख को अवैध घोषित करने का अनुतोष मांगा है और वादी ने मूल्यांकन कम किया है। मेरे कहने का मतलब है कि ये खुद ये चीज़ ये कह रहे हैं कि हाँ ये पैतृक प्रॉपर्टी का ही बंटवारा का केस है और इसके चलते शुरू से इन्होंने भी विनीता शर्मा पर रिलाई किया है। इसका पूरा जजमेंट हम दिखाएंगे तो हुजूर को ये इसमें इनको अभी के समय में ये बात ये कहने का ये इनका कोई मतलब नहीं। और अगर नबादी नामा में भी तो पैतृक संपत्ति का है, दादा का प्रॉपर्टी की बात आ रही है, पिता का वाला जो गिफ्ट किए हैं उसकी प्रॉपर्टी की बात आ रही है।
तो यहाँ पे substantial question of law जो बना है,
Right.
that both the courts have erred in recording finding
Right.
about the nature of properties as ancestral property without framing any issue in this regard.
Yes.
So बना है ना
तो
substantial
सवाल है कि
question of law.
issue
That we will see.
My
So
lord-
therefore, whether the property is ancestral property or not
Right.
is directly subject matter of consideration under substantial question of law number 1.
हम कर रहे हैं, हम मान रहे हैं, लेकिन हमारा ये कहना है कि when they are themselves admitting और ये इसी पर शुरू से
वो तो
बात कर
अभी
रहे हैं।
अभी तो हम लोग उसका आंसर
अब तो हाँ करें, हाँ वही हम कह रहे
Now
हैं
the
कि
point is
जब
that
एडमिशन
this
है
particular issue, whether the property is you see whether the property is ancestral property or not, right? इतना technical issue है ये
हाँ।
कि admission से ये कहानी नहीं चलने वाली है.
हाँ नहीं ठीक है,
It cannot be decided
ठीक
on
है,
admission.
ठीक
It is
है।
absolutely legal and technical issue.
नहीं ठीक है,
In fact, many of the advocates also might not be knowing
Yes, yes,
the difference.
I
हमको तो
agree.
पहले पता ही नहीं था, हम तो इतना 1 साल से second appeal में
ठीक-
बैठ रहे हैं तो हमको पता
Same
चला.
because just I was
So it is,
placing
you
that.
see, these things are very very technical in
लेकिन
nature.
इसमें जो
admission से आप नहीं चल सकते
सब्सटेंशियल
इसमें।
क्वेश्चन ऑफ लॉ हुजूर जो फ्रेम हुआ है
हाँ,
वो ये हुआ है कि इशू बिना फ्रेम किए हुए, तो इशू फ्रेम करना कोई जरूरी नहीं है, इट्स नॉट
ठीक
मस्ट।
है, okay, that's it. We'll
That
see
is what is the
We
substantial
will
question.
see that what is the consequence, what is the contours, and what is the.
Yeah,
But the
yeah.
point whether it is an ancestral property or not is certainly subject matter of consideration in a substantial question of law which has already been framed by this.
हाँ लेकिन इसमें जो नेचर ऑफ सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम हुआ
We
है
will
कि
see
बिना
that.
कोई इशू फ्रेम किए कर दिए।
वो देखते हैं।
इशू फ्रेम करना कोई दरकार तो नहीं है, उसकी कोई आवश्यकता नहीं। और ये जब दोनों पार्टी इसी बात पे ही लड़ रहे हैं, ये इसमें विनीता शर्मा का केस बहस हो रहा है, सारा केस बहस हो रहा है, सब कुछ केस हो रहा है, सब दोनों पार्टी ये मान के चल रहे हैं और दोनों पार्टी ने ये कहा भी है कि हाँ ये एक पारिवारिक बंटवारा का केस है, इसमें बहनों का कोई अधिकार नहीं होगा। और अधिकार इसलिए नहीं होगा चूंकि आपने नबादी नामा हमें देख के दे दिया, ये मुख्य रूप से बस इतना ही तक है और कुछ भी नहीं। और इसमें जो अपीलेट कोर्ट ने इसको तो ट्रायल कोर्ट का हम फाइंडिंग हुजूर को दिखाते हैं, वो ये नबादी नामा एक्चुअल में कोर्ट ने इसको इसलिए नहीं माना, ना कोई डिटेल्स है, ना कोई लैंड का डिटेल्स है, नहीं कुछ और भी कुछ है, तो कोर्ट ने इसे कहा कि नहीं, इस तरह का रिलीज डीट को ना हम बंटवारा नामा मान सकते हैं, ना बंटन नामा मान सकते हैं, हम कुछ भी नहीं मान सकते हैं। ये इस एस्पेक्ट में इसको कहा कि नहीं, ये वॉइड एब इशू है। और कोर्ट ने यह भी कहा कि हालांकि इसका कैंसिलेशन भी जो कल हमने कल हम हुजूर को कह रहे थे, इसका एक कैंसिलेशन डीड भी उसी समय उन्होंने किया था, लेकिन कैंसिलेशन डीड के की इसमें कोर्ट ने कहा कि जरूरत ही नहीं है, चूंकि ये वॉइड एब इशू है, पहला बात। और दूसरा 1994 का 1990
वॉइड एब इशू किस कारण से,
हम बता रहे हैं,
बताइए और कहाँ है, व्हाई इज इट वॉइड एब?
हम लिख पढ़ तो पढ़ रहे 9 को पढ़ा जाए, देखा जाए पेज 21 पढ़ते हैं। वादी का अभिवचन संक्षेप में है। प्रतिवादी संख्या 1 ने 4 ने वादी एवं प्रतिवादी संख्या 5 एवं 6 को विश्वास में लेकर धोखा से पंजीकृत नजमाहीनामा वर्णित भूमि के संबंध में हस्ताक्षर करा लिया, जिसमें इन्होंने यह जानकर हस्ताक्षर किया कि इनके पिता द्वारा अपने पुत्रों के पक्ष में निष्पादित दान पत्र में वर्णित संपत्ति को छोड़ने के संबंध में और इनके दादा द्वारा छोड़ी गई संपत्ति में वादी एवं बहनों के अंशों को आवंटित किया जाएगा, जिस पर विश्वास कर इन्होंने नाबादीनामा पर हस्ताक्षर करा दिए। वादी ने कुछ दिन के पश्चात सुना कि इनके भाई 1 से 4 ने इनका हस्ताक्षर संपूर्ण संपत्ति के संबंध में नाबादीनामा पर हस्ताक्षर करा लिया और कोई संपत्ति वादी एवं इनके बहनों के बंटने के लिए नहीं बची है। वादी को कपट की जानकारी होने पर उक्त नाबादीनामा को पंजीकृत रद्दीकरण विलेख से रद्द कर दिया गया और इस बात की भूमि संयुक्त स्वत एवं कब्जा हो गई। प्रतिवादीगण का अभिवचन संक्षेप में यह है कि यह कहना गलत है कि प्रतिवादी संख्या 1 ने 4 ने वादी एवं प्रतिवादी 5 को विश्वास में लेकर पंजीकृत नाबादीनामा करा लिया है। असल तथ्य यह है कि वादी एवं प्रतिवादी संख्या 5 एवं 6 को नगद राशि एवं सोना उनके अंश के बदले में दे दिया गया है, जो कि उन्होंने नाबादी माना में स्वीकार किया है। नाबादीनामा पर पति के धनंजय यादव, वादी की मां संध्या रानी घोष के पति निमाई चंद्र घोष द्वारा हस्ताक्षर किया है, इसलिए कपट एवं धमकी का प्रश्न नहीं उठता है। उन्होंने सभी तथ्यों को जानकर उजागर हस्ताक्षर किया है। धनंजय यादव ने भी नाबादीनामा के पृष्ठांत में अंतिम लाइन में पेन से लिखा है कि पक्षकारों को वर्णित कथन रूप से बता दिए गए हैं। रद्दीकरण विलेख में केवल वादी द्वारा निष्पादित किया गया है, जबकि नाबादीनामा संध्या रानी, शांति रानी घोष एवं मीरा कुमारी घोष द्वारा निष्पादित किया गया है, इसलिए एक व्यक्ति द्वारा नाबादीनामा को रद्द नहीं किया जा सकता है। वादी का कथन असत्य है। वादी तथा इसकी बहन ने नाबादीनामा पर हस्ताक्षर कर इनके पिता द्वारा अपने पुत्र के पक्ष में किए गए दान संपत्ति के संबंध में किए गए थे, इसलिए वादी निष्पादित रद्दीकरण विलेख को दिनांक इतना पर प्रतिवादन पर बाध्यकारी नहीं है। वादिकारी साक्षी संख्या 1 ने अपने साक्ष्य में कहा है कि 94 प्रतिवादी संख्या 1 से 4 जो मेरे सहोदर भाई हैं, मुझे और मेरी 2 बहनें प्रतिवादी संख्या को विश्वास लेकर यह समझाए कि पिताजी हम 4 भाई को भूमि दान दे दिया है, इसकी जानकारी हम बहनों को नहीं थी। उस पर बहन लोग नादाबी लिख देने के पर दादा के नाम का जो भूमि है वह बहन लोग को मिलेगा। इस विश्वास पर वशीभूत होकर भाईगण के कहने पर हम 3 बहनें 94 में उस भूमि पर नाबादीनामा लिख दिए, जिसमें मेरे पति धनंजय यादव एवं बहन संध्या रानी घोष भाइयों पर विश्वास करके दस्तावेज पर कागज गवाह के रूप में कर दिया। हम बहनों के द्वारा नाबादीनामा दस्तावेज लिखने के कई दिन के बाद मेरे पति के मार्फत इन बहनों को जानकारी मिली कि जो भूमि की सूची भाईगण ने हम लोगों को नाबादीनामा कराया है, वह संपत्ति मेरे पिता द्वारा भाईगण को दान दिया गया संपत्ति नहीं है, बल्कि मेरे दादा बाबूलाल घोष की अर्जित संपत्ति है। इस तरह दस्तावेज छल कपट कर भाईगण द्वारा कुल जमीन डाक पर से लिखा लेने और शेष जमीन पर हम बहनों से नाबादीनामा लिखवा लिए। इस प्रकार हम बहनों के लिए कोई संपत्ति अवशेष नहीं रहने पर हम लोगों के भाईगण के छपट की जानकारी मिलने पर हम तीनों बहन, जिसमें मैं उस समय राजमहल में उपस्थित थी, मात्र 14 दिन के बाद नाबादीनामा दलील को रहित कर निबंधित दलील से रद्द कर दिए। पति परीक्षण में कहा है कि मुझे याद नहीं है कि कौन सा दिन मेरे भाई लोग मुझे नाबादीनामा लिखाने के लिए बोले थे। साल 94 का था। उस समय रजिस्ट्री ऑफिस में मैं और मेरी बहन सुमित्रा घोष, मीरा घोष, मेरी माँ, मेरे चारों भाई, मेरे जीजा जी मौजूद थे। हम सभी लोग नवादीनामा लिखने के लिए इकट्ठा हुए थे। मैं रजिस्ट्री ऑफिस अपने घर से गई थी, बल्कि बाकी लोग कैसे गए थे मैं नहीं बता सकता। रजिस्ट्री ऑफिस में मेरे भाई लोग कहे थे कि दादाजी का संपत्ति बाबूजी हम चारों भाइयों को दान पत्र कर दिए हैं, तुम सब बहन लोग नवादीनामा लिख दो, दादाजी का संपत्ति तुम सब बहन को मिलेगा। भाई लोग के कहने पर मैं नवादीनामा लिखने को राजी हो गई थी। मैं सरकारी कागज पढ़कर उस पर हस्ताक्षर करती हूँ। मैं नवादीनामा लिखी बातों को बिना पढ़े दस्तखत की थी। नवादीनामा लिखे जाने के 2-4 दिन के बाद पति ने बताया कि तुम्हारे भाई लोग बाबूजी को दान पत्र का जमीन पर दस्तखत नहीं करवा के छल करके बाबूजी की जमीन पर, बाबूलाल की जमीन पर नवादीनामा लिखवा दिया। मैं डीड ऑफ कैंसिलेशन में लिखी बातों को सत्य मानती हूँ। ये साक्षी इस बात की प्रतिवादवादी है। इसने अपने साक्ष्य के विवेचन का समर्थन किया है और प्रति परीक्षण में कोई प्रतिकूल साक्ष्य नहीं दिया। वादी नंबर 2 ने अपने साक्ष्य में कहा है कि 24/8/94 से पूर्व प्रतिवादी संख्या 1 से 4 अपनी सहोदर बहन को छल प्रपंच करके यह समझाए कि पिता के द्वारा भाई बहन को संपत्ति दान पत्र में लिख दिया गया है और उसके बहनों द्वारा नादाबी कर देने से दादा के संपत्ति का जो बच जाता है वह बहनों के हिस्सों में छोड़ दिया जाएगा। किंतु बहन लोग जो अपने भाई प्रतिवादी संख्या 1 से 4 के छल प्रपंच को नहीं पकड़ पाई और उनके नवादी में हस्ताक्षर करने को राजी हुई। मैं प्रतिवादी संख्या 5 संध्या रानी घोष पति निमाई घोष का छल प्रपंच नहीं समझ पाए। उनकी बातों पर विश्वास करके नवादीनामा निष्पादन होने के समय उपस्थित रहने की सहमति जताई। प्रतिवादी संख्या 1 से 4 24/8/94 को मेरी पत्नी और 2 बहनें संध्या रानी मीरा घोष को साथ में मुझे निमाई घोष को नवादीनामा निष्पादन हेतु निबंधन कार्यालय राजमहल में उपस्थित होने का अनुरोध किए, जिस पर प्रतिवादी संख्या 1-4 की बातों पर विश्वास कर उनके द्वारा नवादीनामा बिना पढ़े सुने समझकर अपना हस्ताक्षर बना दिया, जिसमें शांति घोष, संध्या रानी घोष, मीरा कुमारी घोष लेखकारी बने और मैं तथा निमाई घोष शनाखत एवं गवाह के रूप में हस्ताक्षर किए।
एक बात बताइए,
मैडम,
the court is appreciating the evidences
no,
based on
I'm
record.
finding पर आ
That's right. The court is appreciating the materials placed on record and is appreciating the evidences by saying that this person had not executed, this person was misrepresented. These things are coming in the evidence. The court is appreciating those evidences.
Yes.
Does this kind of a deed can be said to be void ab initio and
finding
limitation will have no relevance?
पहले हुजूर हमको लास्ट तक पढ़ना।
नहीं, हम तो
हम
फाइंडिंग देख रहे हैं
हम फाइंडिंग हम
साथ साथ में कोर्ट ये भी फाइंडिंग दे रहा है कि ये इस एविडेंस का कोई काट नहीं है।
इसमें हुजूर लास्ट तक इसको लास्ट वाला पढ़ा जाएगा।
लास्ट वाला पढ़ेंगे, लेकिन एट द सेम टाइम the fact remains that the court, while considering the legality and validity of these documents, right, is also considering the oral evidences as to who had signed, how who had signed, whether there was any misrepresentation, whether there was any fraud. These things are required to be proved by cogent evidence, which the court is recording. Therefore, your contention that that limitation will have no role to play. How do you stand on that?
I want to say that जब ये पॉइंट ये सब आया है, इसमें देखा जाएगा लास्ट में खाली 2-3-4 पॉइंट दिखा रहे हैं कि रिलीज डीड में कंसिडरेशन कुछ नहीं मेंशन है, डिटेल्स ऑफ लैंड मेंशन नहीं है, कुछ भी नहीं है। आप हम आपको छोड़ रहे हैं 2 क्वेश्चन हमको
के लिए कंसिडरेशन क्या लिखना है?
एक मिनट थोड़ा हमको
If a person wants to say that I will not claim anything on this property,
several Supreme Court judgments has been relied upon. Your Lordship may allow me to read it. हम इसमें रेलेवेंट
से हस्ताक्षर करा लिए,
हम रेलेवेंट
ये सारा एविडेंस को कंसीडर कर रहा है कोर्ट और इसका लिमिटेशन को नहीं कंसीडर कर रहा है।
इसको देखा जाए लास्ट पे हम पढ़ते हैं पारा 26 पढ़ा जाए। अंतर वस्तु वर्णित है, इसकी अंतर वस्तु वर्णित है कि मृत दादा बाबूलाल गोप, मृत सुनायन गोप और हक हम आप लोगों को पहले ही पा चुकी हूँ। इस विलेख में यह वर्णित नहीं है कि पूर्व में अपने बाप दादा के नाम की पैतृक संपत्ति में कौन सा संपत्ति पाई है जिससे कि विलेख बंटवारा का रूप ले सके, तथा इस विलेख में वर्णित 50 कट्ठा 15 धूर भूमि आप लोग का हक प्राप्ति है जो आप 4 भाई लोग भोग दखल कर रहे हैं। उक्त उल्लेखित संपत्ति में हम लोगों का कोई हक नहीं है और वह आप लोगों का हक संपत्ति प्राप्त है जब लेखकारी वादी और उसकी बहनों का उक्त विलेख में कोई अंश ही नहीं है और वह इन संपत्तियों पर अपना हित लेखदारी के पक्ष में कैसे छोड़ सकती है।
पेज नंबर पढ़ रहे हैं?
पेज 26 से लास्ट से पढ़ रहे थे।
26
का लास्ट
right?
लास्ट
Just
पैरा
a
से
moment.
पढ़े फिर से पढ़े।
नहीं ठीक है, सुन ही रहे।
उक्त उल्लेखित संपत्ति में हम लोगों का कोई हक नहीं है, आपका कोई हक।
लेकिन इस विलेख में परिणित नहीं है कि यह पूर्व में अपने बाप दादा के नाम की पैतृक संपत्ति में कौन सी
संपत्ति पाई है जिससे कि यह विलेख बंटवारा का रूप ले सके तथा इस विलेख में वर्णित 50 बीघा 15 कट्ठा 19 धूर संपत्ति का कुल आप लोगों का हक प्राप्ति है जो आप भाई लोग के दखल कर रहे हैं। उस संपत्ति में हम लोगों का कोई हक नहीं है, वह हम लोगों का अंश प्राप्त संपत्ति है जब लेखगारी इस वादी एवं बहनों का उक्त विलेख की संपत्ति में कोई अंश नहीं है और वह इन संपत्तियों पर अपना हित लेखकारी के पक्ष में कैसे छोड़ सकती है। इस विलेख की अंतर वस्तु से स्पष्ट है कि लेखकारी इसको इस बात की जानकारी नहीं है कि इस विलेख में वर्णित संपत्ति में इसका कोई अंश है या नहीं। इसलिए विलेख
just a moment, if a person is executing a relinquishment deed in connection with a property in which he has no right, right, then that particular deed would be null and void, right? Whether these sisters will have any right over the property or not will essentially depend upon the fact whether it is an ancestral property or it was a self-acquired property, right? And that is already a subject matter of consideration. If it is ultimately held that they had no right on the property, it is irrelevant whether there is a gift deed or there is a relinquishment deed. Therefore, if it is ultimately held that it was ancestral property, then under such circumstances, the limitation will certainly come into play. We cannot, because this is one of the reasons. There are many other reasons.
Right.
But if this reason is so clinching, that if the person executing the gift deed suppose the property is held to be ancestral property, then the father did not have the right to gift the entire property, correct? Right? Because there are other co-partners with respect to that property, he cannot have the exclusive right to gift.
With respect to.
And if it is held that it is not an ancestral property, then he had got all the right to gift.
But here in this case, you must kindly appreciate.
So therefore, whether the point of limitation, whether the deeds were voidable or void, will essentially depend upon the answer to substantial question of law number 1. And therefore, the point of limitation does arise for consideration.
My Lord, I kindly appreciate. So far as the present case, Your Lordship is concerned, the entire nature of pleadings, entire evidence, everything Your Lordship will then consider. You will not, my Lord will not have any doubts in mind that the entire argument, entire things, entire judgment, both the courts, Your Lordship, is on the point itself that it is an ancestral property.
Just a moment. Mr. Sharma, please appreciate. If we ultimately find what you are saying to be correct, then there can be no doubt that this particular deeds, the registered gift deed and the relinquishment deed, would be void. Because the daughters would have no right over the property. You can still argue that these are void because they had no right over the property because of the finding with regard to the nature of the property. But ultimately, if it is found that it is not an ancestral property, or it is an ancestral property, then the point of, therefore I want, what I felt, little that I have read about these two judgments, I feel that the point as to whether these deeds were void or voidable.
There is a recent judgment on this point also.
Whether these deeds are void or voidable is a point for consideration, and if it is held to be void, there is no question of limitation. But if it is held to be voidable, then the limitation will certainly be attracted to this.
That aspect has also taken note by the trial court. Your Lordship may kindly allow
Must
me to
have.
read that. They read only that part only. That part.
कौन सा पद है?
एक पेज 38 योर लॉर्डशिप में काइंडली इंटरनल पेज 38 इसके आधार पर वाद भूमि का स्वत्व एक से प्राप्त हो गया है और उक्त दान पत्र एवं नाबादी मानों को निष्पादन के
कहाँ से पढ़ रहे हैं पता ही नहीं
पेज
Top से
37 का
38
लास्ट पार्ट है
अच्छा,
और
37
38
का
का
last।
फर्स्ट पार्ट
37 का लास्ट
जी
ये पढ़िए तो पूरा।
हाँ पढ़ लेते हैं। वादी का अभिवचन संक्षेप में यह है कि वादी द्वारा प्रतिवादी संख्या एक के पक्ष में निष्पादित दान पत्र प्रतिवादी वादी के पक्ष में निष्पादित नबादी नामा अवैध एवं शून्य एवं वादी पर बंधनकारी न होने से घोषणा एवं बंटवारा आदि का अनुतोष के लिए प्रस्तुत किया है। प्रतिवादकगण का संक्षेप में यह है कि पिता के द्वारा प्रतिवादी संख्या 1 से 4 में पक्ष में निष्पादित दान पत्र एवं वादी पक्ष के द्वारा सच और सच के में निष्पादित पंजीकृत नबादी नामा वैध दस्तावेज है और इसके आधार पर वाद भूमि का स्वत्व 1 से 4 को प्राप्त हो गया है और उक्त दान पत्र एवं नबादी नामा को निष्पादन के 3 वर्ष के अंदर में करके संसाधित किया जा सकता है। जबकि वादी ने दान पत्र 72 में निष्पादित होने तथा नबादी नामा वर्ष 94 में वादी वर्ष 2005 में स्थापित किया है। इसलिए वादी का वाद मर्यादा विधि के प्रावधान से बाधित है। पूर्व विवादकों में सूर्य नारायण घोष द्वारा प्रतिवादित 1 से 4 में निष्पादित 4 दान पत्र एवं नबादी नामा को प्रारंभतः शून्य घोषित निर्गित किया है और प्रतिवादी ने नबादी नामा को निष्पादित किया है तथा वादी ने 1/8 अंश प्राप्त करने का अनुतोष मांग किया है। वादी ने यह वाद 21/11/5 को प्रस्तुत किया है, इसलिए नबादी नामा निष्पादित करने के 12 वर्ष के अंदर में ही न्यायालय में प्रस्तुत किया है। यद्यपि दान पत्र प्रारंभतः शून्य तथा नबादी नामा
कब है शून्य इसलिए है बिकॉज दे हैड नो राइट टू एग्जीक्यूट।
हाँ उसको बहुत सा चीज कंसीडर करके किया है
That is the core reason that it is null and void because they did not have the right to execute.
दो वजह से इसको कहा गया है। गिफ्ट डीड का अलग है, इसका नबादी नामा का ये कहे है कि नबादी नामा में जो कंटेंट्स है जो उसमें लिखा हुआ है उसके आधार पर ऐसा कोई रिलिक्विशमेंट नहीं हो सकता है, प्रारंभतः शून्य। ये बात उन्होंने कहा। एक इसके बावजूद भी कह रहे हैं कि प्रारंभतः शून्य है तथा नबादी नामा को कराया गया दान पत्र की जानकारी प्रस्तुत करने में प्रस्तुत हुई है, मर्यादा विधि से बाधित नहीं। ये खुद कह रहे हैं,
खुद कह रहे का बात नहीं है ना, बात ये है
12 साल के अंदर में भी कह रहे हैं
क्या चीज कर
12 साल के अंदर में भी ये सूट लाए हैं इसके लिए।
ठीक है, वो तो देखिए जब 12 साल के अंदर की बात होती है ना तो वॉइड एंड वॉइडेबल अगर judgment है तो we have to see no whether it is null and void or it is voidable. The question of limitation will come. The question of limitation will come only if it is a voidable deed. If it is found to be void, there is no question of limitation.
Yes.
The law is very well settled.
very certain.
And whether these deeds are void or voidable is essentially dependent upon the first substantial question of law which has already been taken by this court.
But my lord मैं काइंडली
जब इनका
नेचर ऑफ जब इनका ब्लीडिंग सब कुछ
we will see that ना, वो तो हम लोग तब देखेंगे जब
ये क्वेश्चन नहीं,
वो हम लोग तब देखेंगे जब हम लोग फर्स्ट सब्सटेंशियल क्वेश्चन ऑफ लॉ के साथ इस सब्सटेंशियल क्वेश्चन ऑफ
नहीं ठीक है, उसमें हमें कोई आपत्ति नहीं।
इतना ही है।
और सो फार एज दिस अपीलेट कोर्ट इज कंसर्न, ट्रायल कोर्ट का फाइंडिंग हम लिमिटेशन पे दिखा दिए। अपीलेट कोर्ट ने यह कह के ये नहीं माना, चूंकि विनीता शर्मा केस जो है राकेश शर्मा वर्सेस विनीता शर्मा में ऑनरेबल एपेक्स कोर्ट ने कहा है कि कोई भी ऐसा तरह का कोई अगर जब तक कोई रजिस्टर्ड अगर पार्टीशन डीड हो या कोई कोर्ट का डिग्री हो, इसके अलावा जो भी इस तरह का कोई अगर ट्रांजैक्शन है, कोई फ्रॉडलेंट नेचर का ट्रांजैक्शन है जिससे अगर कोई डॉटर्स के राइट को अगर आप ब्रीच करना चाहते हैं तो दैट विल नॉट बी परमिटेड। ये हम
फ्रॉडुलेंट नेचर का हो ना तो फ्रॉडुलेंट नेचर का एडजुडिकेशन चाहिए।
नहीं तो एडजुडिकेशन करने के बाद दो कोर्ट ने कहा।
That's right. Therefore, if it requires adjudication, then it is voidable. Simple. If अगर कोई डीड को धोखा से एग्जीक्यूट करा लिया,
सिर्फ धोखा का बात नहीं है, सिर्फ अगर धोखा का बात रहता तो वहां तक ठीक था। यहाँ पर बात ये भी है कि जो डीड का कंटेंट्स है वो रिलीज डेट के आधार पर वो राइट होगा ही नहीं। इसमें हम खाली अपील कोर्ट का एक पैराग्राफ दिखा रहे हैं। अपील कोर्ट का एक पैराग्राफ जरूर देखिए। पारा 17 पेज 17 हजूर इसको दिखा जाएगा, पेज 25 पर,
पेज
25 अपीलेट।
yes.
This has been relied by both the parties to buttress their respective arguments. The legal proposition which has been settled by Honorable Apex Court are as follows. If the daughter is alive on the enforcement of Amendment Act 2005, that is 99/2005, irrespective of whether she was
आपका
born,
पेज नंबर मैच नहीं करता है, कौन सा पेज पढ़ रहे हैं?
हम internal page 17 of the appellate court judgment पर।
Yes.
ये लॉ कोर्ट किए हैं। लॉ कोर्ट करने के बाद ये लिख रहे हैं कि interpreting the provisions of section 6 and thereafter all judicial pronouncement till date, the Honorable Apex Court, Honorable Supreme Court of India has finally settled the law and the succession of ancestral property and the shares of daughters in the Vinita Sharma versus so and so, and this judgment has been relied by both the sides to buttress their respective arguments. The legal proposition which has been settled by the Honorable Apex Court are as follows. If the daughter is alive on the date of enforcement of Amendment Act, irrespective of whether she was born or before the said amendment, provisions in the substituted section 6 of the Hindu Succession Act confer status of co-partner on the daughter born or after the amendment in the same manner as the daughter with the same rights and liabilities, meaning thereby a daughter becomes a co-partner, since the birth and in this case dies after the coming into force of amendment is inheritance not by survivorship but in the state of the testamentary succession as substituted 6.3. It has been further held by the Honorable Apex Court that the substituted section 6 gives right to daughter by birth unobstructed heritage. During deeming provision or legal fiction cannot be extended beyond the purpose for which it is created. Amendment in Hindu Succession Act is done for the purpose of providing the legitimate share of daughters in the ancestral property like sons. Provisions under exempting provisions which are effected before 2012-2004 are either by a final decree or a duly registered terms of registration act, partition deed. Having regard to the fact that earlier exclusion registered document for partition was not always necessary, the court was rarely approached to sake of family prestige exception carved out to amend section 5 explanation by holding that though in view of the rigor of the provisions of explanation of to section 5, oral partition cannot be accepted as a statutorily recognized mode of partition. Further, even if the partition is supported by a registered document, it is necessary to prove that it has been given effect to and acted upon and not otherwise a sham or invalid. Nature and applicability of said amendment are of retroactive application. They confer benefits on the antecedent dates, that is the right given by birth and the mitachara co-partnership shall be deemed to include a reference to a daughter as a co-partner. Meaning thereby the Honorable Apex Court in the above judgment of Vinita Sharma versus Rakesh Sharma has held that daughters are co-partner by birth and has further held that their interest in the ancestral property is protected unless the property is divided prior to the amendment either by way of a final decree of partition of court or by a registered partition deed. The other modes which affects to partition of ancestral property and deprive the share of daughters in the ancestral property are invalid. Implication of law of limitation in the devolution of succession of ancestral property and its settlement either by way of consent decree or thereby relinquishment of share by way of exclusion of power of attorney and subsequent challenge on the basis of fraud, misrepresentation, etc. decided in Ranganama, Kama versus and others, case Prakash dead through LRs as reported in 2008 by volume 15 SCC. In this case, Honorable Court interpreted the provision of Order 6, Rule 4 and 2 of CPC and Section 19 and 20 to 30 of the Contract Act and has held that a voidable contract is required to be challenged by filing a suit. And in case the limitation will apply. But where the contract is void itself, it cannot be acted, and for there is no
Mr. Sharma,
requirement to be
it
challenged for the
requires-
question of applicability.
Truly आपका।
आगे लिखें।
जब सब्सटेंशियल क्वेश्चन ऑफ लॉ समझने में इतना टाइम लग रहा है तो बनने ही लायक।
हाँ बिल्कुल।
तो बनाते हैं। तो बनाते हैं ना, फिर सुनेंगे आपको कहाँ मना कर रहे हैं? डिसाइड थोड़ी कर रहे हैं।
वो तो आपका हजू का वो तो आप इस पे
नहीं बिना सुन के तो नहीं डिसाइड कर सकते। बिना सुन के तो नहीं।
I cannot object, but
Because you see these
that has been properly answered. That's what I am saying.
We will see that. We will see that if it had already been properly answered, there is no problem.
And
The matter is intricately related to the right of a daughter under the Hindu succession.
yes,
It is intricately related to that.
Yes.
So therefore, these relinquishment deeds, this gift deeds, will essentially fall for consideration.
one last para he has specifically referred this that Honorable Apex Court has said that if such deeds are there, it has to be scrutinized by court closely.
That is why these deeds have been scrutinized by court closely.
And after close
once-
scrutinization, the
That's
court
right.
has come to a finding that it is only to deprive the rights of the daughters. That what it has been held.
So देखना
Yes.
पड़ता है ना, उसके बिना तो कैसे?
नहीं ठीक है.
इसीलिए बिना फ्रेम किए तो नहीं देख पाएंगे ना. तो इनका एडिशनल you see what I propose is A, whether gift deeds and relinquishment deeds
वो तो है.
were void or voidable, right? B, if voidable, then whether it was barred by limitation. बस इतना. You see whether these deeds were void, ab initio or voidable, correct? And if it is held to be voidable, then under such circumstances whether it was barred by limitation. इतना सही बस.
ये क्वेश्चन जो कल हो रहा था whether the cancellation of relinquishment deed is barred by limitation. That has already been answered.
सर वो गलत है.
That has already been answered.
वो तो null and void ही है. Cancellation of a deed is null and void. तो उसके लिए कोई
No question of limitation.
question of law. क्योंकि इन्होंने जो आपको कल ही बोले थे, अगर पढ़ के हमको लगेगा कि कोई question of law है, irrespective of whatever she has proposed, we can frame it like
Yes,
this.
that is
is why
lordship
I am
prerogative.
hearing you so much.
That is your lordship prerogative. My lord can always frame a substantial
That's
question.
right.
That I cannot
इतना ही
object.
खाली करना
cannot
है
object.
और कुछ नहीं करना. बाकी इनका जो प्रपोज सब्सटेंशियल क्वेश्चन ऑफ लॉ है, यानी कि ये वाला
30 लिखा था।
जो हम लोगों ने कल ही लिखा था ना 1, 2, बाकी जो 1 and 2 है ये तो ऑलरेडी कवर्ड है. यस मैडम, इज दैट करेक्ट? Substantial question of law number 1 and substantial question of law number 2 are already covered.
And only one more question of law, Your Lordship, that
About-
whether the claim of the plaintiff or respondent herein for share in the
That will automatically follow. You see, the moment the property is held to be ancestral, the consequences will follow.
But then also it has a limitation period also for
No,
claiming
for-
for ancestral property. Your
No,
Lordship.
for ancestral property you can claim because there is unity of title. You can claim possession.
There is no
can claim
unity of
partition.
title right now. So that will
There
be
is unity of title even for ancestral property. If it is ancestral property, there is unity of title. You are governed by Mitakshara law.
Yes.
If you are governed by Mitakshara law, उसमें इस तरह का कोई limitation का issue भी नहीं राइज करता है कि हम यहाँ पे एक तो नया point of limitation बना. You fought the case on the point of limitation with regard to the gift deeds and with regard to the relinquishment deeds. So
But if-
after hearing them, these two questions can be framed and no other.
What if there are more substantial questions?
There is no further. We will start hearing what do you mean more substantial question of law.
No, only this one.
Only
Your
this.
worship.
Only these.
After the period of limitation, whether the alienation of the property can be challenged?
So this is what I'm framing.
See, alienation of the property, first the gift deed was executed in the year 1972.
Yes.
And the relinquishment deed was executed in the year 1994.
That's
They
right.
filed the suit for partition
Okay.
in 2005.
Fair enough.
So whether the alienation of the property,
So
the
therefore,
challenge of that is
that will
barred
be-
by limitation or not?
That's right.
Yes.
This is how it is.
No, that
That is
law
that
need
you are
to
not
be
listening to the question of law. You are not listening to the substantial
Your
question of law, which
kindly,
you just listen
yes.
to the order.
My lord may frame it that so far as the finding with respect to the, my lord, the limitation, whether that is correct or not. To that what my friend is also saying, that what my lord is also saying.
Essay number 83 of 2023 with IA number 14478 of 2025. Heard the learned counsel for the parties on the proposed additional substantial question of law through the interlocutory application. Further, the counsels have also advanced their argument if there is any other substantial question of law involved in this case. It is not in dispute that the case involved in this second appeal inter alia relates to applicability of Hindu Succession Act as amended in the year 2005 with respect to right of daughters in the family. It further appears that the suit property was gifted to the sons in the family, to
By
the
father.
by the father, to the exclusion of the daughters,
Yes.
and relinquishment deeds were also executed
With respect to the grandfather's property.
with respect to the grandfather's property, and relinquishment deeds were also executed.
Yes.
The gift deeds are dated
72.
there are four gift deeds, number 2521, 2522, 2523 and 2524, all dated 22/7/1972, and the relinquishment deeds, how many are there?
It is five. One.
And one relinquishment deed, number 4836 of 1994, correct? एक ही है, सब चारों ने एक साथ किया, which are involved in this case. The parties had joint issues as to whether these gift deeds and relinquishment deeds whether challenge to these gift deeds and relinquishment deed were barred by limitation. The plaintiff, the three daughters, the four daughters had also prayed for a declaration that
No, only one daughter has prayed for the
Only one daughter.
okay, the plaintiff also sought for a declaration that the suit property was ancestral property. This court finds that one of the substantial question of law already framed by the order dated 30/11/2023 is relating to the point regarding the nature of property being ancestral property. During the course of arguments, it transpired that if the property is ancestral property, then under such circumstances, the granddaughter may have some right over the property,
Like sons.
like
Sons.
allied sons. But if the property is self-acquired property of the grandfather, then upon his death, the property may not be termed as ancestral property in the eyes of law. May not be. I'm just simply stating may not be. Therefore, an intricate point arises for consideration as to whether the gift deeds and the relinquishment deed were void ab initio or were voidable. And if the same were voidable, then a further question would certainly arise as to whether the suit was barred by litigation. In view of the aforesaid facts and circumstances, this court is of the view that following substantial question of law arises for consideration in this case. Whether the learned courts were justified in holding that the gift deeds and relinquishment deeds were void ab initio, instead of holding the same to be voidable. If this question
that is not needed.
Okay,
void.
Void ab initio, and if this question is answered in favor of the appellant, if this question is answered in favor of the plaintiff, then certainly there may not be any question of the suit or their challenge being barred by limitation. But if it is found that these documents were voidable, then a further question will certainly arise as follows: whether the challenge to gift deeds and relinquishment deed were barred by limitation.
One thing I would like to say, in the light of the judgment passed by the apex court in the Vinita Sharma case, now the court has to give effect. The Honorable Apex Court has said so, that the legislature, the purpose for which the law has been enacted, it has to be given effect. It has to be given effect. But rather, it is the onus is on the other side.
So
it is not on us. Not on us, because it pertains to a daughter's right.
You see, the issues or the alienation which has already been settled, right? There is no question of.
What I mean to say, in cases like this, in which there is a legislative intent for the daughters, in favor of the daughters, then it is the court has to be scrutinized it closely and not to scuttle it unless there is something. Otherwise not.
We'll see that. We'll see that from that angle also.
Yes.
We'll see that.
You may frame it.
I've already said.
Because the appellate court has granted rights.
The question of law is quite widely worded, and I think there will be enough scope for argument on these aspects.
Appellate court has given the rights to daughters on the basis of the judgment passed by Honorable Apex Court in the Vinita Sharma case itself.
That's right. We'll see that. So, when do you want to do it? Anything else you want to say, madam?
No, these questions of law.
हाँ बताइए. अब कब करेंगे?
छुट्टी
बताइए कब करिएगा?
छुट्टी के बाद
एक्सपोज के बाद शुरू कर दिए.
डेट बताइए.
सेकेंड वीक में.
Second.
Specific date maybe.
A specific date is always there. You tell us when will you do it? Calendar.
Much scope has been given to us.
नहीं देखिए, सब्सटैंशियल क्वेश्चन ऑफ लॉ बनाने के पहले बहुत सोच के बनाना चाहिए. ऐसे एरर होने से बहुत गड़बड़ेगा. फिर लगता है कि हियरिंग के समय कुछ हो सकता था लेकिन नहीं हुआ क्योंकि सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं। एक जजमेंट में देयर वाज अभी मतलब वेरी रिसेंट देयर वाज अ फाइंडिंग दैट इट इज बैड फॉर नॉन जॉइंडर ऑफ नेसेसरी पार्टीज। इस पर कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना, तो आंसर होके भी क्या होगा, सूट तो खत्म हो गया। ये सारी चीजें तो सोच के नहीं बनाने से। When you want to do it, madam? Tell me, आप बाहर से आते हैं, आप बताइए कब करेंगे। ये लोग तो यहीं पर हैं।
Yes. Okay, the second week of Jan 17th or 18th.
19th. 19th is Monday. Monday is okay for you? करेंगे? 2:15 नहीं हो सकता और मैथ तो कैसे? I do not know what bench would be there.
ये भी बस है।
With the consent of the learned counsel for the parties, pose this case for final hearing on 19th of January.
Can it be
Counsel, sorry,
one request? Can it be high on the list so that
we can't decide it. You have to mention it with the consent of the parties. सबका फोन नंबर लेके रखिए। हमारा बेंच रहेगा तो हम तो सुन लेते हैं, लेकिन I do not know how will other benches will take it. कभी-कभी ऐसा भी होता है कि नया केस है तो इतना जल्दी भी क्या है, ऐसा भी होता है। So we cannot anticipate क्या होगा। Parties to prepare short notes, short synopsis with list of relevant dates and the judgments which they seek to rely upon, to be filed at least 5 days in advance. 5 days. Finally, this meeting. आइए dispose of.
there is another we are having on 19th stay of the execution
अभी
petition.
क्या अब हम कुछ चलिए। एक आइए एडिशनल डॉक्यूमेंट के लिए क्या फाइल किया?
Stay of the execution petition.
अच्छा, एक ही आइए पेंडिंग है,
Yes.
2 आइए और पेंडिंग है। दिखाइए सर।
There were 2 IAs, one for stay
There
of
are 3 IAs which are pending. एक तो डिस्पोजल हो गया, ये आईए नंबर 14478 डिस्पोज ऑफ।
14478.
डिस्पोज ऑफ। इसके अलावा
8536 for stay of the execution petition.
इसका भी कॉपी आपको नहीं मिला है।
भाई आप दे दीजिए मैडम, ऐसा कॉपी के लिए ऐसा मत। ये स्टेट
ये
We
पहले से
appeared,
I'm not appearing first time.
we are yesterday only.
आप तो यहाँ पे रहते हैं ना, आपका तो काम है देने का, कि कॉपी लेने के लिए खाली डेट लेते हैं।
बाद में पेज के
बाद में कैसे नोटिस के बाद हम आए आप जाते हैं फिर आफ्टर नोटिस
दे दीजिए।
जी
From supplementary list for hearing on order 41 to 11 item 3 second April 34 of 2019.
नहीं देख पाए, कोई टाइम नहीं था। I was busy with some work. Argument has already been recorded on that.
यस
day.
यस
The arguments have already been concluded on 16/12/2025 on the point of claiming substantial question of fact. Pose for orders on opening January 6 तारीख। Orders substantial question of law बनाने के लिए।
From date is item 30 second April 419 of 2016.
This is a title dispute wherein joint compromise has been done. We have filed an IA. It was filed yesterday, because of which it is not on record
We'll
today.
bring it on the phone. They mangai unta. Who is for the other side?
419 item 30.
V. Kumar. Bhaiya V. Kumar, as per the order.
Where is he?
Earlier also one, it was filed, but at that time it was dismissed because we were required to substitute some respondents. That has been done, and now it's a fresh joint complaint.
You have filed a press compromise.
Yes.
All the persons are party in this joint
Yes.
compromise.
Yes.
Let's have a look. कहाँ है इसका joint compromise?
It's IA number 17044 of 2025.
No substantial question of law has been framed so far.
No. Just to go through. No, in addition, no substantial.
Apart from respondent number 5 to 16, rest of the respondents are joined for the joint compromise.
Yes, sir.
He is not coming, it seems he is not interested in compromise.
It may be adjourned for.
Adjourn किस लिए adjourn हम लोग कर रहे हैं? Adjournment करने के लिए बैठे हैं यहाँ पर.
I informed the opposite party.
Call him. Either you call him or you argue on the substantial question of law. I will reject your argument. If they are not interested, we will not hear them. Why should we hear them? For framing substantial question of law, I don't need the respondents. Right? Then if they are not interested, we will dismiss the joint compromise on this ground that counsel is not coming.
A short passover may be granted.
Right. मिस्टर बीवी कुमार को 2-3 बार बुलाना पड़ता तभी आते हैं, ऐसे नहीं आते. For every case we have seen least interested. और जब केस DFD हो जाता है then he come running.
Item 31, second appeal 84 of 1023.
On behalf of the appellant, I will be seeking an adjournment, ma'am.
Why do you need adjournment?
Reason behind one document, important document need to be brought and record for
By
which
way of last indulgence, the matter was adjourned on the last occasion. Isn't it?
one handwriting expert need to be brought and record. Certified copy has been applied, but it has not been supplied as yet. And that handwriting report is there in the judgment.
It must have been considered.
No, it has not been taken into consideration.
It was exhibit number?
It was exhibit number 1. It was not taken into consideration. Reason behind the handwriting expert was not examined. Though he was called for, but he was not examined. Therefore, that handwriting report was not taken into consideration.
It was not exhibited. Therefore, it cannot be taken into consideration. How will it be taken into consideration? If the handwriting expert does not present himself for his cross-examination, how his report can be taken into consideration?
The reason behind the report is of utmost importance. That matter is with regard to the payment of 30,000 by way of advance. If that report,
You see, if there is a report of handwriting expert which has been placed, and if the handwriting expert does not come to exhibit that document, then how can that be taken into consideration? The cross-examination of handwriting expert is equally important. So, on this
allow
ground,
me
the
to
case
bring
cannot.
that on record.
No, there is no requirement to bring it on record. How will you bring it on record? By filing supplementary affidavit. It is already there in the record. It is available.
It has not been brought. LCR may be called for.
We will not call for them. You argue with this.
Kindly sought adjournment to be granted.
The trial court judgment is 6th of October 93.
Trial court judgment is of the year 94.
93.
93.
6th of October 1993. सूट कब का है? Yes.
$89.
89. अब तो हमको 9 मिनट भी फुर्सत नहीं. बस करिए. 89 का सूट लेके बैठे हूँ.
Meantime, the matter has been remanded back.
Maybe we don't bother about it. After all, it's a suit of 89. Default in payment of rent?
No default in payment. That's what I was saying.
That's right.
It was
That's
no,
right, but it is a dispute arising out of landlord-tenant relationship. A suit of 1989.
It is the plaintiff contention that there is a default of rent. But we have contended that there is no default of rent as because we have paid 13,000 by way of advance. For that reason, previous second appeal of the year 96 was remanded. And
What was the second appeal number?
it is on the record that is second appeal 42 of 1996.
हाँ, ये तो हम last time तो ये इसीलिए तो इन्होंने time लिया था. He was appearing on that day. आज आप appear हो रहे हैं इसलिए आपको मालूम नहीं. It is 46 or 42. दोनों में से कौन सी?
42 of 96.
पार्टी का क्या नाम है इसमें?
Ram Kumar, Harisankar and others versus Sri Gopal Kasera. this order, the earlier eviction decree order passed in that eviction suit was set aside, and it was the court below, first appellate court was directed to take the additional evidence.
Okay, then what happened? So argue your case. Yes, please argue your case.
Short passover may be given in that matter, because Amit Das will be doing it.
So why are you here for?
Completely ready.
This is the way you conduct your case. Not completely ready. You are here only to seek adjournment. Then, if your senior is not there and I have started seeing the record, now you will say that somebody else will argue. You did not pray for an adjournment at the threshold.
I was looking after the matter in the court below.
Well, you are the
copy
best one
was
to know.
certified. I was supposed to. I didn't got the certified copy.
That makes no difference because because the handwriting expert never came to the court for a cross-examination. Who produced that document?
The document was produced by the defendant.
You are the defendant, correct? Why your handwriting expert did not come?
As the
It was for you to
at
produce the
that
handwriting
particular
expert,
point
no?
of time, I was not in practice.
That's right, in 1989 you might not be in practice. But the point is, he was your witness. You did not bring him. Now you want this court to believe in your handwriting expert document.
As because issue number 4 of the court below, trial court, that whether the defendant defaulted in payment of rent from 4th of July 89 till filing of the suit, and that is with regard to that receipt which has been paid and which was sent for handwriting expert.
You read the finding of the trial on default in payment of rent. What is the date of filing of suit?
Date of filing of suit.
'29 September. Cause of action is 29 September. Date of filing.
May I read issue number 4, finding?
read issue number.
The plaintiff has stated that the defendant are tenant in the suit premises at the rate of rent of rupees 525 per month, and rent have also not been paid from or Shudhi Sambat such and such corresponding to 4th July 89. Hence, the suit is filed on 30th of November 89 for eviction of non-payment of rent till the date of filing of the suit. The defendant has filed written statement but nowhere has stated that they have paid rent for the month for which they are alleged to be defaulted. However, the defendant Ramkumar Garodia, defendant number 6, has stated in para 10 of his evidence that they have not paid rent since 4/7/89. The defendant has alleged that originally rate of rent was rupees 25. The plaintiff has assessment register prepared under 105 Municipal Act, from which it transpires that rent was originally paid at rupees 20 and Harishankar has been shown as tenant. The defendant has alleged that 12 years back rate of rent was enhanced to rupees 325, but Harishankar Garodia, who has been examined on commissioner, has said in chief that it was enhanced to rupees 125, then 150 and then 350 and ultimately 525. He has not said that ever the rent was 325 from rent receipt filed on behalf of defendant, which are exhibit B/3 and B/4. It appears the prior to rupees 525 rate of rent was 350 and it was in the year 1986. During cross-examination, the plaintiff has admitted that from Diwali Sambat rate of rent was 525. Now the question arises whether the defendant has paid 13,000 as advance rent to the plaintiff and the same is liable to be adjusted, and as such the defendant has not defaulted in payment of rent. The defendant have given notice to the plaintiff for adjustment of rent, which are exhibit C. This notice was given on 15/9/89, but he has not alleged about 13,000 advance paid to the plaintiff for adjustment. On this point, the defendant has examined Murari Lal Sarma, DW2, who is employee of the defendant firm, and he has said that on 16/7/89, 13,000 was given to the plaintiff as advance. During cross-examination, he said that it was reduced into writing. In para 5, he further said that 13,000 was not given as rent, but the plaintiff has said that it will be counted at the time of calculating the rent. DW6, Ramkumar Garodia, defendant himself has said during cross-examination in para 12 that this sum was paid by Harishankar, his uncle, in his presence, and he further stated in para 6 of cross-examination that this amount is shown in income tax and he can file the document showing the sum. He further said that he cannot say in whose return the same has been shown, but there is a possibility that this is shown in the income tax return of the firm. He further said that he can file talpat of that date, but no such return has been filed. Harishankar Garodia examined on commission. He said in cross-examination that on 17/7/89, rupees 13,000 was paid to the plaintiff as advance, and he has contradicted that his allegation that this sum was paid on 16/7/89. PW5 has said in cross-examination that this sum was paid rent, but he cannot say from which month it was paid. Thus, I find that there is contradiction in the statement of defendant and his witness on the point of payment of rent as advance of 13,000. Under this circumstance, I am of the view that the theory adopted by the defendant that he had paid rupees 13,000 as advance liable to be adjusted towards future rent. It is not established by the defendant by oral documentary evidence. It is also admitted that the last rent was rupees 350 and it was enhanced to 525 from Diwali such and such. prohibited any enhancement of rent except as provided in section 5 and 6 of the act. They cannot enhance rent by agreement without taking recourse of section 5 and 6 of the act. So far adjustment of advance rent is concerned, it is well settled principle of law that excess rent will not be automatically adjusted. The defendant has claimed that the plaintiff has taken 62,400 as excess rent and this sum is liable to be adjusted. The defendant Ramkumar Garodia, examined at DW6, has said in his cross-examination that he has not given detail of excess rent in his notice and he cannot give account of the same. That how he has given rupees itna as excess rent. In the notice itself, only itna is claimed but not explained in detail. Harishankar Garodia admitted in cross-examination that when plaintiff asked for the rent, he never said for adjustment and for the first time in writing for adjustment of rent. He further said that he also failed to examine from which month he is claiming for adjustment of rent. Most of the sum claimed adjustment is time bar. In the recent judgment such and such, Supreme Court has decided the both point of enhancement and adjustment of rent and has held that section 4 of BBC Act creates absolute prohibition against illegal increased or enhancement of rent manner provided under the Act itself. The Act does not contain any prohibition for automatic adjustment of excess rent. Tenant must claim set off within period of limitation in respect of amount paid as excess rent, otherwise tenant is liable to be evicted on account of default in payment of rent. As discussed above, the defendant has failed to establish any definite case of set off for adjustment of rent and has not paid court fee for set off of excess rent. They did not do, hence claim of defendant for adjustment of rent is also considered on this account as well. It was contended on behalf of defendant that Exhibit D, it is clear that rent of 4 months, that is for last such and such rent was taken by plaintiff and DW4 it transpired D4 it transpired that on 30/10/1986 rent for 6 months was accepted. In this way any rent was not realized from month to month but according to the convenience of the party, but in BBC Act theory of convenience is not acceptable and there is no provision for payment of rent according to the convenience. If the tenant defaulted in payment of rent for more than 2 months shall be treated to be defaulter. Even after acceptance of rent, it is open for the landlord to bring a suit for willful default under the provision of BBC Act. Learned counsel for the defendant also contended that this is not case of willful default, but I find that the defendant have faithfully admitted that they have not paid rent since itna sent or tendered the rent, and as such they are defaulter and liable to be evicted from the suit premises on the ground of default in payment of rent. Thus I find and hold that defendant have defaulted in payment of rent since 4th July 89 and as such liable to be evicted on this score alone.
Detailed order has been passed. All the materials has been discussed by the learned first appellate court after the order of remand. Right? You wanted to adduce this particular document as additional evidence, which was objected to, and your handwriting expert did not come to prove the signature. It was your witness. There is nothing in this case.
Still I will seek for an adjournment.
No, I will not.
Whatever date
That prayer is rejected. Second appeal number 84 of 2023. The second appeal has been filed against the judgment dated 13/12/2023.
I also think that did this matter come on Monday?
Rejected.
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 The date this
Prayer
matter
is
was
rejected.
on 6th it was taken up. I informed the
I
client.
have, you see, we don't bother about it.
Madam, I informed the client about the documents that we need to go through. Because you must say this expert witness, the handwriting witness was not our witness. We provided a list of experts. This was a we have a
We do not
petition.
know.
We have a
See,
petition.
I've heard you on the, whatever has been written in the accused judgment, and that's it.
Whatever was written was a title suit judgment. Thereafter, the matter went till the Honorable High Court, and it was remanded. And the civil appeal order was the one order against which the appeal has been made. And I must say that in the civil appellate order, the contradiction that has been brought by the first appellate court has been DW5 was the witness that was examined after this additional evidence was adduced, and he has been contradicted with respect to all the other witnesses who were examined way before in 1993. Now this DW7 was examined in 1997-95. The contradictions cannot be sustained because
That does not constitute a substantial question of law.
therefore,
Second appeal, please hold on. I've heard him. There is no question of parallel hearing.
therefore I was playing.
Therefore, you sit down. Second appeal number 84 of 2020. This appeal has been filed against the judgment entity dated 30/12/2022, within bracket decree signed on 5/1/2023, bracket rules, passed by Learned Additional Judicial Commissioner 1 Ranchi in civil appeal number 17 of 1994, whereby the first appeal has been dismissed. The trial court judgment and decree is dated 16/10/1993, within bracket decree signed on 25/11/1993, bracket close, passed by the municipal Ranchi in eviction suit number 58 of 1989, whereby the suit seeking eviction inter alia on default in payment of rent was decreed. The defendant has lost in both the courts, and consequently, the second appeal has been filed. The learned counsel for the appellant has submitted that the matter was that earlier the first appeal was decided in title appeal number 17 of 1994/10 of 17 of 1994/10 of 1995, and upon an appeal filed by the tenant before the High Court in second appeal number 42 of 1996, within bracket R, the matter was remanded to the first appellate court. He submits that thereafter the present impugned order passed by the first appellate court has been passed. The learned counsel has submitted that the money receipt amounting with respect to rupees 13,000 was adduced as additional evidence before the learned first appellate court pursuant to the order of remand, and the same was relatable to payment of advance and was dated 16/7/1989. He submits that if this amount would have been adjusted, then there is no question of default in payment of rent. The learned counsel have also submitted that the report of handwriting expert the learned counsel has submitted that the report of handwriting expert with respect to the money receipt of rupees 13,000 has not been taken into consideration by the court, and therefore a substantial question of law arises for consideration. He has also submitted that the evidence of the witnesses have also not been properly considered by the learned First Appellate Court on remand. After hearing the learned counsel for the appellant, that's all.
Only one thing. I have asked my learned friend to ask the client for withdrawal because the execution has already been disposed of. So just 2 minutes खाली पूछ लेते हैं लॉर्डशिप. He is asking the client. Because the only issue was the lordship that whether handwriting expert can be taken on record.
He has not been examined, cross-examined on that.
हाँ लेकिन expert report.
एक्सपर्ट रिपोर्ट ऐसे एक्सपर्ट रिपोर्ट हैंडराइटिंग एक्सपर्ट रिपोर्ट ऐसे होता है कितना सीनियर काउंसिल है हैंडराइटिंग एक्सपर्ट रिपोर्ट ऐसे एग्जामिन होता है विदाउट क्रॉस एग्जामिनेशन उसका कोई वैल्यू
The
नहीं.
court sent it to that expert and he did not.
He was your witness. He was your witness. Anyway, speak instruction.
Just because execution has already been disposed of.
Please come back. If you don't come back, I'll dismiss it.
Yeah, I am waiting.
Password case item 30.
I talked to the opposite party counsel. He is in Giridi because of death of some relative. He left today only and was not able to inform anyone.
Who all have filed the respondent number 19? बताइए कौन कौन फाइल की? Respondent number 18, 17, 24. So when does he want?
Any other day. It's comfortable.
Any other day means कल रख देंगे तो you will not be here, no? Then
told that
any
he-
other day means what?
But it may be put up on Monday.
ID number 17044 of 25 has been filed by way of joint compromise. Counsel for the appellant is present. He has submitted that the counsel for the respondent has gone out of station on account of a bereavement in his family and submits that the matter be posted on Monday. Post on Monday at 2:15. और भी रखे ना मंडे को at 1 o'clock. 10:30 बजे वो नहीं भी आते हैं कभी, इसीलिए 1 बजे तक.
Appearance.
AC number 84 of 23. The learned counsel for the appellant. You are not withdrawn. Okay. आधा लिखा है ना आपको? अभिनीत जी लिखी
After hearing लिखा है. Fine. After hearing the learned counsel.
हाँ. After hearing the learned counsel for the appellant, this court finds that the plaintiff had filed the suit for eviction on ground of default in payment of rent, and for a decree of sum of rupees 2,625 as arrears of rent. The learned trial court, the suit was contested. And a specific plea was taken. A plea was taken that the plaintiff had realized a total sum of rupees 62,400 by way of illegally enhanced rent, and the same was liable to be adjusted towards rent from 4th of July 1989. And a further plea was also taken that the plaintiff had requested the defendant to pay a sum of rupees 13,000 as an advance on the ground that he required money which was paid on 16/7/1989. And a plea was raised that on account of the aforesaid facts, the inter alia on ground of the aforesaid fact, the defendant could not be said to be a defaulter in payment of rent. The following issues were claimed by the learned trial court. Para number 4. The issue number 3 was decided by holding that the point that there was a relationship of landlord and tenant between the parties was not contested, and it was decided in favor of the plaintiff. While deciding issue number 4, the learned trial court considered the materials on record, both oral and documentary, and ultimately also considered the question as to whether the defendant had paid rupees 13,000 as advance rent to the plaintiff, and it was liable to be adjusted. The learned court further considered the evidence in that connection and was of the view that the theory adopted by the defendant that he paid rupees 30,000 as advance rent, which was liable to be adjusted towards future rent, was not established by the defendant by oral or documentary evidence. And it was also admitted that the last rent was rupees 350 and it was enhanced to rupees 525 from it was not established by oral or documentary evidence. The learned court also considered the claim of the defendant with regard to excess rent of rupees 62,400, but the court recorded that no basic details in connection with the said amount was given, and was of the view that the defendant failed to establish any definite case of set-off of adjustment of rent and had not paid the court fees for set-off of excess rent, and therefore the claim of defendant for adjustment of rent was not considered. The learned court ultimately held that the defendant had defaulted in payment of rent since 4th of July 1989 and was liable to be evicted. The plaintiff was also entitled for arrears of rent of rupees 2,620. This judgment was challenged by the defendant in Title Appeal number 17 of 1994/10 of 1995, which is apparent from the final judgment passed in essay number 42 of 1996 within bracket R, passed by this court, whereby the said judgment passed by the learned first appellate court was set aside and the matter was remanded. Apparently, the defendant was the appellant in the second appeal, and the defendant had lost before the learned first appellate court in the first round. However, in second appeal number 42 of 1996, which was disposed of by the order dated 14/1/1997, it has been recorded that at the second appellate stage, the defendant had filed a petition under Order 41/27 of CPC seeking to adduce additional evidence regarding payment of rupees 13,000 on 16/7/1989 as advance to the plaintiff. With respect to the additional evidence, this court in second appeal number 42 of 1996 observed that the plea of payment of 13,000 on 16/7/1989 was taken by the defendants at the very first instance, but regarding its payments, although several documents were referred to at the time of evidence, but not about any document or receipt regarding such payment was referred to, as the said document was not in the hand of the defendant at the stage of trial or at the stage of first appellate court. Before the High Court, they had come up with a plea that such document could not be found out on search, and ultimately it was found. The court observed that whether the document, the receipt of payment regarding 13,000 on 16/7/1989 was procured or not, or manufactured, the same can be decided if the same is put on trial by way of additional evidence. And was of the view that a chance should be given to the defendant to produce the additional evidence in this respect alone. The court ultimately also observed with regard to the other points, and observed that enhancement of rent has already been decided by both the courts, both the fact-finding courts, and on the basis of full bench decision of this court, the matter has been set at rest and the same cannot be agitated now. And the court observed that on this score, the defendant had no case. The court also observed that although other points were found in favor of the plaintiff, but in respect of default in payment of default and in respect of decree regarding rent from 4th of July 1989 was required to be reconsidered as the defendant were coming up with a fresh document in support of their contention of payment of advance rent. The court observed that the pair under Order 41 Rule 27 of CPC was allowed, and the matter was sent back to the First Appellate Court to give opportunity to the defendant to adduce additional evidence on the document of payment of advance rent as mentioned above alone. And it was also observed that the plaintiff should also be allowed to lead evidence in rebuttal. And the matter was remanded. Upon remand, the defendant upon remand, the plea of payment of rupees 13,000 by the defendant on 16/7/1989 as advance rent was duly considered by the learned First Appellate Court, and the only point for determination before the court was as to whether the defendant was able to prove his plea on his payment of rupees 13,000 on 16/7/1989 as advance rent, and the same was liable to be adjusted, and as such the defendants had not defaulted in payment of rent through oral as well as documentary evidence, and whether the defendant committed default in payment of rent. ये है point for determination at page number 16. The learned First Appellate Court considered the oral and documentary evidences, and while considering the same, the learned court recorded the contradictions in the evidence of the defendants and also recorded that defendant number 8, contrary to the evidence of defendant number 4, 5 and 6 had stated that Exhibit F was prepared regarding payment of rupees 13,000 to the plaintiff, but plaintiff had not admitted his signature on the same, and therefore this money receipt was marked exhibit with objection of the plaintiff. The court also observed that the expert opinion was obtained regarding the said signature, and the court issued dusty summons for examination of expert, but the expert was not examined by the defendants, and therefore the defendants could not prove the genuineness of the money receipt amounting to rupees 13,000 paid on 16/7/1989. The court further observed that DW 4, 5 and 6 also admitted that no such document was executed regarding payment of rupees 13,000 as advance on 16/7/1989. The court further observed that the evidence of DW 7 showed that he was not in a position to say that whether any document was reduced into writing regarding this transaction or not. The learned court further observed that DW8 had stated that Shiv Bhagwan Patwari prepared the receipt of amount of rupees 13,000 and signed by the plaintiff Gopal Kasera before him, but the version of DW8 that the document exhibit F was prepared before him was falsified by the evidence of DW7, Harishankar Garodia, who claimed to give rupees 13,000 to Gopal Kasera in presence of his elder brother Ram Kumar Ji, Raj Kumar Ji, Murari Lal Sharma, Ram Akhtar, and Kishan Lal Poddar. The learned court ultimately recorded that it showed that neither DW8 nor Shiv Bhagwan Patwari were present at the time of so-called transaction. The learned court further considered the Exhibit C, which is a notice of the defendants dated 15/9/1989 regarding adjustment of rupees 62,400, which was alleged to have been illegally collected by the plaintiff as rent. But in the same notice, there was nothing mentioned about the advance of rupees 13,000 paid on 16/7/1989 to the plaintiff for rent. The court also took into consideration that DW6 himself admitted in his evidence that rent was not paid since 4/7/1989. Because he asserted that rupees 13,000 was paid as advance for rent, and it stood admitted from the side of the defendants that they did not pay rent with respect to the suit premises for the period from 4/7/1989 onwards. Since the DW7 had himself stated that an amount of rupees 13,000 was paid to the plaintiff as advance on 16/7/1989, but in his cross-examination he stated that he could not say as to whether any receipt was obtained or not. This court finds that the first appellate court ultimately, after scrutinizing the materials on record, was of the considered view that the defendant failed to prove that they had paid rupees 13,000 as advance rent to the plaintiff on 16/7/1989. This court finds that upon perusal of the judgment of the learned first appellate court, this court finds that there was enough material that the defendant, through their oral and documentary evidence, have failed to prove that rupees 13,000 was paid as advance, and ultimately the learned first appellate court held that the defendant was a defaulter in payment of rent, and the suit was and dismissed the appeal. This court finds that no substantial question of law is involved in this case, and accordingly this appeal is hereby dismissed. You want your appearance to be recorded? You want your appearance to be recorded?
Yes.
Give your name.
Yes.
ये साथ में लिख दीजिए.
Advice for withdrawal for the reason that execution dispose of हो गया तो कुछ बचता नहीं है. It should.
ऐसे बिना इंस्ट्रक्शन के विड्रॉ नहीं कर सकते.
हाँ नहीं तो क्लाइंट बोला कि नो भी.
नहीं ठीक है. It's his right. Execution
में the plaintiff confined only for realization of rent, and rent we have paid. Then he applied for fixation of fair rent. That was done. We are paying. So I asked him that he withdraw it. But he said no, you are.
From supplementary list for order be deferred item 1. Second appeal filing number 2419 of 2025.
In this appeal, my lord, I filed IA for including the heirs of the late appellant number 3, Pankaj Kumar Gupta as a performer respondent number 26 to 28.
Why addition of party?
The office has pointed out a defect that the appellant number 3 of CC of degree has not been made party in memo. My lord, the appellant number 3 died on 26/2/2025. After the judgment and decree and before filing of this appeal.
IA number 6692 of 2025 in second appeal, filing number 2419 of 2025. Council for the applicant has submitted that this utility application has been filed for addition of party, inasmuch as on account of the fact that appellant number 3 in civil appeal number 1 of 2022 died on 26/2/2025 after passing of the impugned judgment and decree, and therefore in his place, Pankaj Kumar Gupta लिखेगा नाम. In his case, his legal heirs have been made party in the appeal. Death certificate. He submits that the death certificate of Pankaj Kumar Gupta has already been placed on record. Considering this aspect of the matter, the office defect regarding defect number?
Defect number 25-1.
Defect number 25-1.
उसमें 2 ठो था, 3 और 8. 8 तो ऑलरेडी सिविल अपील में ही सब्स्टिट्यूट हो गया था, तो 8 का तो करेक्शन हो गया, डिग्री करेक्शन होके आ गया था.
With regard to 25-1 is ignored for the present. तो उसका इसमें ऑब्जर्वेशन हो गया होगा ना?
हाँ, अब वहाँ पे रेस किए थे, लवाजमा में आया था तब रेस किए थे उसको.
That's right. Anything else? Office is directed to face this case. Opening week का कोई Tuesday, Wednesday.
इसमें तो नंबर पहले रजिस्टर्ड होगा तभी.
इसीलिए ऑफिस will do it.
From daily
सर
list.
आप किस केस के लिए बैठे?
बहुत अर्जेंट मैटर. मेरा डिमोलिश decree is being executed in my house on which family living.
मैटर कहाँ पर? अभी लाइए.
एक आइए ना.
कोई बात नहीं, बताइए क्या है? अदर साइड कहाँ है?
Item 5.
Where is other side? अभी आके चले गए, 4:30 बज गया, सोचे चले जाते हैं. सीनियर बैठे हुए वो छोड़ के चले जाएंगे ऐसे.
बोले भी कि करेंगे.
हाँ करेंगे, बुलाने दीजिए. अभी बाहर बैठ के वीडियो देख रहे होंगे. बताइए क्या है सर, क्या मैटर है
ये हुजूर
2006 का है ना सर? इसमें तो
इसमें स्टे हुजूर मिला, इसमें सब्सटेंशियल क्वेश्चन बन चुका है.
कौन सा ऑर्डर से?
हुजूर 10/12/21.
10/12/21
और उसी से एडमिट करके मिलॉर्ड द स्टे वाज ग्रांटेड. फर्दर प्रोसीडिंग इन एग्जीक्यूशन केस वाज स्टेड.
एक सेकंड सर, इशू नंबर 6 पे कोई फाइंडिंग नहीं है?
कोई फाइंडिंग नहीं है.
इशू नंबर 6 क्या है सर, बताइए.
इशू नंबर 6 था कि वो मिलॉर्ड वी आर डिफेंडेंट्स एंड द plaintiffs filed suit. They are claiming मिलॉर्ड Daniel Murmu. Now plaintiff is claiming मिलॉर्ड on the basis of घर जमाई marriage मिलॉर्ड with his wife. Now जो उसकी वाइफ है डेनियल की, तो उसकी माँ का नाम है सारो. तो सारो का 2 जगह शादी हुआ ऑर्डिनरी फॉर्म में. मतलब ये फाइंडिंग आया ट्रायल कोर्ट का. इशू नंबर 6 मिलॉर्ड. इशू नंबर 6 वाज डिसाइडेड कि सारो मुर्मू यानी जो डेनियल की जो सास है, वो शी वॉज नॉट मैरिड इन घर जमाई फॉर्म. उसकी 2 जगह ऑर्डिनरी मैरिज 2 शादी हुई.
2 शादी कैसे होगी?
माने एक जगह शादी हुई हुजूर, उसके बाद वो दूसरी डेथ हो गया उसका, फिर दूसरी शादी कर ली. सो 2 ऑर्डिनरी फॉर्म में मैरिजेस हुआ. नाउ दिस इज द ट्रायल कोर्ट फाइंडिंग लॉर्ड, एंड विच वॉज नॉट इवन टच्ड, whispered लॉर्ड by the appellate court. and which was the main issue.
प्रॉपर्टी किसका? डेनियल का है?
प्रॉपर्टी हुजूर, प्रॉपर्टी
किसका है?
प्रॉपर्टी है ये जदू मुर्मू और पंडू मुर्मू, ये दोनों भाई थे माय लॉर्ड। तो जदू मुर्मू डाइड विदाउट सन, तो उनकी बेटी का नाम था वही सारो मुर्मू माय लॉर्ड।
उनकी बेटी का नाम था
सारो मुर्मू, और सारू की फिर बेटी का नाम मार्गरेट करके आया, वो क्रिश्चियन होकर डेनियल से क्रिश्चियन मैरिज हुआ है उसका, मैंने सारो की बेटी का।
लेकिन सारो की शादी
ऑर्डिनरी फॉर्म में हुई है। दिस इज द फाइंडिंग ऑफ द ट्रायल कोर्ट।
तो भी आप कैसे हार गए?
हुजूर रिवर्सल, we had won in the trial suit, we are defendants.
ट्रायल कोर्ट का फाइंडिंग का है नंबर 6 में।
ट्रायल कोर्ट का फाइंडिंग हुजूर मैं दे रहा हूँ। लॉर्ड जस्ट
सर फाइंडिंग दिया है कि एक सेकंड सर सुनिए तो मेरा बात। फाइंडिंग ये भी है कि क्रिश्चियन में कन्वर्ट हो गया है एंड देयर इज नो कांसेप्ट ऑफ हजमाई फॉर्म ऑफ मैरिज।
ये भी है।
इफ देयर इज अ फाइंडिंग टू दिस इफेक्ट, तो कौन सा ट्राइबल लॉ से गाइडेड होगा ये केस ट्राइबल लॉ से कैसे गाइडेड होगा?
हाँ, घर जमाई का
ट्राइबल लॉ से गाइडेड नहीं होगा ना?
हाँ, नहीं होगा।
तो फिर
नहीं होगा। तो हम लोग एडॉप्टेड सन हैं हुजूर। जदू का भाई पांडु का बेटा संग्राम, एंड संग्राम हैड नो इशू, और संग्राम ने फिर हमको अडॉप्ट किया है। सो वी आर डिफेंडेंट्स मिलॉर्ड क्लेमिंग एडॉप्शन मिलॉर्ड। ट्रूली मिलॉर्ड घर जमाई मैरिज नहीं होगा।
adoption has been held valid?
held valid मिलॉर्ड by the trial court. और आज 100 साल से ये पुश्तैनी हम लोग के मकान में हम लोग रह रहे हैं हुजूर, और ये एग्जीक्यूशन में ऑर्डर कर दिया है कि डिमोलिश कर दीजिए जाके घर को, और स्टे हुजूर इस कोर्ट से मिला हुआ था पहले। स्टे जो मिला था यहाँ से मिलॉर्ड, वो 2 महीने के लिए ही मिला था, और उसके बाद फिर हमने पूरा अपने आईए में एक्सप्लेन किया है कैसे कैसे वो नहीं हो पाया, और उसमें सब्स्टिट्यूशन वगैरह भी कई लोग डेथ कर गया, उसका सब्स्टिट्यूशन वी आर परस्यूइंग मिलॉर्ड विजिलेंटली, एंड नाउ पूरी फैमिली हुजूर स्ट्रीट पर आ जाएगी। और वो ऑर्डर हम लोग लगाए एग्जीक्यूटिव कोर्ट का आईए में मैलॉर्ड, जिसमें कहा है कि इनका हाउस भी जाके डिमोलिश कर दें। नोटिस भी हम लोग लगाए हैं हुजूर एग्जीक्यूटिव कोर्ट का, उसमें 12 तारीख का ऑर्डर था कि मैजिस्ट्रेट वगैरह के साथ हम लोग आ रहे हैं डिमोलिश करने, लेकिन वो क्लाइंट्स हमारे आए हुए हैं। 12 तारीख को डिमोलिश नहीं हुआ आज तक। 14-12 पूरी फैमिली आज 100 साल से रह रही है उसमें। और नहीं हो तो फाइनल इसको हियरिंग भी किसी भी दिन कर लिया जाए। वो क्वेश्चन ही फ्रेम नहीं हुआ अपलेट कोर्ट के द्वारा सारो मुर्मू लेके हुजूर इश्यूज वाला वो पैराग्राफ दिखा रहे अपलेट कोर्ट का। Lord, para 42 of the appellate court's order, judgment, page 24. इंटरनल पेज 24। सारो मुर्मू की शादी घर जमाई में हुई कि नहीं, ये क्वेश्चन ही फ्रेम नहीं हुआ, एंड दैट वाज द मेन इशू, बिकॉज डैनियल इज क्लेमिंग हिमसेल्फ टू बी द घर जमाई, घर जमाई ऑफ सारो मुर्मू। पेज 24 मिलॉर्ड, पैरा 42। ये क्वेश्चन ही फ्रेम नहीं हुआ, इशू, एंड विच वाज द मेन इशू मिलॉर्ड। Whether Saro Murmu was married in Garjamai, no issue framed by the appellate court.
क्या बोलना आपको?
मतलब जो आया फाइल हुआ है तो कॉपी नहीं मिला, इसमें को रिप्लाई देना था।
आपको कॉपी दे देते हैं, स्टे कर देते हैं।
मतलब मंडे को रख दिया जाए, पार्ट कर दिए मैडम।
एडमिटेड केस है ना सर,
तब मंडे को कर देते हैं ना, हम लोग कर देते हैं।
इतना हमको एफिशिएंसी नहीं है
आज मतलब तैयार नहीं हो पाए।
कोई बात नहीं, आप तैयार होइए, कोई दिक्कत नहीं। तो आप कॉपी के लिए सर्व करते हैं?
नहीं मिला, नहीं
कॉपी दिए
कब दिए हैं?
देखा जाए 15 तारीख को फाइल किया था, हमको नहीं मिला, हमको नहीं मिला। मिलता तो हम तैयार होगा।
विदाउट सर्विस तो फाइल नहीं होगा।
अभी कोर्ट में बैठे टाइम इनको दे दिए थे कि देख लीजिए।
नहीं सर, तुरंत कैसा हो जाएगा?
उसका जो 2019 में जो आईए फाइल हुआ था उसका कॉपी मिला था ना?
वो सब है, 19 का है अभी इधर।
वही तो एक्सटेंड करना है।
2024 का नहीं है, 2025
जब एक ऑलरेडी स्टे है तो उसी को एक्सटेंड करना है।
हम उसको कंटिन्यू कर दीजिए, वो आपको दिक्कत नहीं, हमको
उसी को कंटिन्यू करना है।
हमको सिर्फ कॉपी चाहिए था।
कोई जरूरत नहीं है यार, इसको फाइनल हियरिंग करेंगे आप लोग।
इसको अगर मैटर अगर मंडे रहता तो ठीक रहता।
उतना स्पीड हमको नहीं।
मंडे को सेकंड टाइम
इसीलिए उतना स्पीड आपकी तरह स्पीड वाले हम नहीं है भाई, वकीलों को बहुत स्पीड होता है, हम लोग थोड़ा स्लो लोग। ऐसे नंबर 23 of 2006. The learned counsel for the appellant has submitted that the case has been admitted for final hearing by framing a substantial question of law. Earlier, an interim order was passed staying the execution proceeding. In state high execution का
Stay for 2 months was granted or
that's right, no problem.
My lord, 2 months का था कि इस बीच में प्रयास करके आप लोग इसका हियरिंग करा लें। वो पूरा एक्सप्लेन किया।
Staying the execution proceedings by order dated 10/12/2021 in IA number 4001 of 2019. But the stay was only for a period of 2 months. He submits that the ये आगे भी पेंडिंग है क्या है?
वो आइए पेंडिंग ही है।
IA number 4001 of 2019 is still pending, and in the meantime another interlocutory application being IA number 5648 of
वो भी पेंडिंग ही है।
22 has been filed, praying for stay of execution.
For extension
for extension of
मिलोड और सब्सिक्वेंटली फिर हमने दिया कि सब डेथ उथ हो गया सर रिस्पोंडेंट में, तो सब्स्टिट्यूशन पिटीशन सब के लिए मैंने एक्सप्लेन किया कि हम लोग लगातार लगे हुए हैं, परसू कर रहे हैं विजिलेंट।
The learned counsel for the respondents has submitted that he is otherwise ready for final hearing of the matter, and the matter can be posted for final hearing on Monday also, right?
Yes, ma'am.
Considering the fact that we are on the verge of winter break, accordingly, this court is not inclined to fix this case for final hearing on Monday. However, the matter is directed to be posted for final hearing on date बताइए तो बताइए इसके लिए। कब करेंगे बताइए? 7 जनवरी को?
10 के बाद रखें या
7 तारीख एकदम बहुत अच्छा शूट।
ठीक है मिलोड, वी आर ऑलवेज देयर।
उस दिन मेरा ओथ हुआ था।
माय लॉर्ड्स,
7th of January 2026 for final disposal, right?
We'll also celebrate.
That's right.
Milord.
The interim order passed earlier on कौन सा डेट था interim order का?
वो डेट था हुजूर 10/12/21
10/12/2021 नहीं ऐसे लिखिए further proceeding in execution case number such and such execution
7th
in TE number 7
Milord
of 2006 is stayed till 7th of January 26. Sir, तैयारी करिए. The counsel for the parties are directed to prepare short synopsis of arguments and a list of dates. And also furnish the judgments which they seek to rely upon. Just 1 day prior to the next date of hearing.
सब टू
आइए डिस्पोज ऑफ दोनों आइए को डिस्पोज ऑफ करें बोल दाई
एक और 16909
ये कि 16909 ये किस लिए
16909
जो डिमोलिश करने के लिए जो नोटिस वगैरह दिया उसके लिए
वो हर एक नोटिस का आइए कर रहे हैं क्या आप लोग
प्रेजेंट में जो दिया था डिमोलिश करने के लिए उसके
सब आइए डिस्पोज करें
मिलो सात को इसको सुन लिया
इन केस दिस केस सात को सुनेंगे
मिलोड
और अगर नहीं होता है आपका मैटर तब स्टे करेंगे लेकिन उस दिन 4:30 बजे मत आइएगा बोलने के लिए एक्सटेंड कर दीजिए
मिलोड
10:30 बजे बोलेंगे नहीं टेंशन